and we have to comply with the law. Now, yesterday I gave you a condensed form of instructions because it was rather late in the day. So I gave you the highlights, but I'm going to read to you at this time the general instructions in a criminal case that you will be governed by throughout the trial. You can take them home with you. They make excellent bedtime reading if you have some insomnia, but they're yours to keep, but you need to follow them throughout the course of the trial. Number one, do not mingle with nor talk to the attorneys, the witnesses, the parties, or any other person who might be connected with or interested in the case except for casual greetings. They, as I told you, have to follow these same instructions, and you will understand it when they do. Number two, do not accept from nor give to any of the persons any favors, however slight, such as rides, food, or refreshments. Three, do not discuss anything about the case, including with each other, or even mention it to anyone whomsoever, including your wife or husband, nor permit anyone to mention it in your hearing until you are discharged as jurors or excused from this case. If anybody attempts to discuss the case with you, report it to me or one of the officers immediately. Do not even discuss the case amongst yourselves, as I told you, until all of the evidence is closed, you have heard the charge of the court, the attorney's arguments, and you have been sent to the jury room solely at that time to deliberate on the verdict. Do not make any independent investigations about the facts of the case. To privately seek out information about the case on trial is improper. All evidence must be presented in open court so that each side may question the witnesses and make proper objections. This avoids a trial based upon secret evidence. These rules apply to jurors the same as they apply to the parties and to myself. If you know of or learn anything about the case except from the evidence admitted during the course of the trial, you must tell me about it at once. You have just taken an oath that you will render a verdict on the evidence submitted to you under the charge and under my rulings and nothing else. Do not make personal investigations, inspections, observations, or experiments, nor personally attempt to view premises, things, or articles not produced and admitted in court. Do not let any third party or anyone else do these things for you. Do not tell other jurors about your own personal experiences or those of other persons, nor relate any special information. A juror may have special knowledge of matters such as business, technical, professional, scientific, or he or she may have expert knowledge or opinions, or he or she may know what happened in this or some other lawsuit. To tell other jurors any of this information is a violation of these instructions. Do not seek information contained in law books, dictionaries, public or private records, or elsewhere which is not admitted into evidence. I am further instructing you specifically that you are not to secure or attempt to secure any information of any type relating to this case from the internet, social media, or any other vehicle. Please turn off cell phones and other electronic devices while in the courtroom and while deliberating. Other than taking care of personal business, do not communicate with anyone through an electronic device such as a phone, text, email, chat, blog, tweet, Facebook, etc. Do not post any information about the case on the internet before these court proceedings end and you are released from jury duty. Do not record or photograph any part of these court proceedings. At the conclusion of all of the evidence, I will submit to you a written charge. Since you will need to consider all of the evidence admitted by me, it is important you pay close attention to the evidence as it is presented. The Texas law does permit proof of any violation of the rules of proper jury conduct. By this I mean that jurors and others may be called upon to testify in open court about acts of jury misconduct. I instruct you, therefore, to follow carefully all of these instructions which I have given you, as well as any others that come up during the course of the trial which you may later receive. You may keep these instructions and review them as you wish. A violation of these instructions should be reported to me immediately. Respectfully submitted, Sid Harrell, presiding judge. With that, ladies and gentlemen, you were impaneled and sworn yesterday. At this time, Both sides have an opportunity to make what is known as an opening statement. What the lawyers say in the opening statement is not to be construed as evidence in the case, but they do have the right to summarize what they believe the evidence will show in the case. The state has the opportunity to go first. The defense may either immediately follow them or reserve their opening statement to the opening of their own case. So I'll ask the state to address you at this time. Did y'all have the indictment already? Yeah. Okay, Ryan, do you have it? The amendment? All right, ladies and gentlemen, we are going to read the indictment, but with certain qualifications that I was going to address with you, and then we'll do the opening statements. There's 29 counts, as we discussed yesterday when we did the voir dire. Both sides have agreed to not read the entire indictment. They are going to read the indictment, selected counts. They are identical. They'll describe that to you. And then at the conclusion of the reading of the indictment, I will have the defendant enter his plea as to the entire indictment, each and every count therein. But once again, they're not going to read each and every one to you at this time. So you may proceed. Would you stand, please, for the reading of the indictment?
I'm going to read the first two counts of the indictment. The State of Texas versus Adrian Gonzales in the District Court of the 38th Judicial District of Uvalde County, Count 1. In the name and by the authority of the State of Texas, the grand jury for the County of Uvalde, State of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term of 2024 of the Judicial District Court for said county and said state, upon their oaths, present in to said court at said term that Adrian Gonzales, hereinafter style the defendant, on or about the 24th day of May, 2022, and before the presentment of this indictment in the county and state aforesaid, as a peace officer for the Uvalde Consolidated Independent School District by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Emanuel Flores Jr., a child younger than 15 years of age, in imminent danger of bodily injury, death, physical impairment, or mental impairment by engaging in one or more than one of the following omissions. After hearing gunshots and after being advised of the general location of the shooter by witness 1, and having time to respond to the shooter, the said Adrian Gonzales failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. After hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the said Adrian Gonzales failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one or more than one child or children in rooms 111 and 112 of Robb Elementary School. And the defendant, as a peace officer, had a duty under the provisions of Article 6.06 of the Texas Code of Criminal Procedure to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. And under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, the defendant, as a peace officer, had a duty, after being informed in any manner that a threat had been made by one person to do some injury to another person, to prevent the threatened injury if within his power. And the defendant, as a police officer of the Uvalde Consolidated Independent School District, had a duty under Section 37.081 of the Texas Education Code to protect the safety and welfare of people in his jurisdiction. And the said defendant did not voluntarily deliver the child named above to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Count 2. And it is further presented that Adrian Gonzales, hereinafter styled the defendant, on or about the 24th day of May, 2022, and before the presentment of this indictment in the county and state aforesaid, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, place Uzziah Sergio Garcia, a child younger than 15 years of age, in imminent danger of bodily death, physical impairment, or mental impairment by engaging in one or more of the following omissions. After hearing gunshots and after being advised of the general location of the shooter by witness 1, and having time to respond to the shooter, the said Adrian Gonzales failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. After hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the said Adrian Gonzales failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one or more than one child or children in rooms 111 and 112 of Robb Elementary School. And the defendant, as a peace officer, had a duty under the provisions of Article 6.06 of the Texas Code of Criminal Procedures to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. And under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, the defendant, as a peace officer, had a duty, after being informed in any manner that a threat had been made by one person, to do some injury to another person to prevent the threatened injury if within his power. And the defendant, as a police officer of the Uvalde Consolidated Independent School District, had a duty under Section 37.081 of the Texas Education Code to protect the safety and welfare of people in his jurisdiction. And the said defendant did not voluntarily deliver the child named above to a designated emergency care provider under Section 262.302. Count 3 is for the child of Javier Lopez. Count 4 is for the child Jace Carmela Luevano. Count 5 is for the child Annabelle Guadalupe Rodriguez. Count 6 is for the child Alexandria Anaya Rubio. Count 7 is for the child Layla Marie Salazar. Count 8 is for the child Ileana Torres. Count 9 is for the child Rogelio Fernandez Torres. Count 10 is for the child Nevaeh Alyssa Bravo. Count 10 is for the child Jacqueline Jalen Lazarus. Count 11. Count 12 is for the child McKenna Queen Elrod. Count 13 is for the child Liana Garcia. Count 14 is for the child Tess Marie Mata. Count 15 is for the child Miranda Gail Mathis. Count 16 is for the child Alethea Haven Ramirez. Count 17 is for the child Maeta Yulena Rodriguez. Count 17 is for the child Jayla Nicole Seguero. Count 19 is for the child Amarie Joe Garza. Count 20 is for the child Noah Oscar Arona. Count 21 is for the child Chloe Merlinda Torres. Count 22 is for the child Jordan Demetrio Olivares. Count 23 is for the child Jaden Gonzales. Count 24 is for the child Samuel Salinas. Count 25 is for the child Kendall Faith Olivares. Count 26 is for the child Mia Seville. Count 27 is for the child Gilberto Mata. Count 28 is for the child AJ Martinez. and count 29 is for the child Maya Zamora.
All right. Once again, both sides have agreed to allow the defendant to enter the plea as to all 29 counts, but not read all 29 counts. So, ladies and gentlemen of the jury, all 29 counts will be set out and will be in the final charge of the jury. But at this time, in regard to the entire indictment, sir, how would you like to plead, guilty or not guilty?
I'm not guilty.
All right. Thank you. You can be seated. The court will receive your plea in the causes. And again, typically, ladies and gentlemen, I read the indictment immediately after you're impaneled and sworn, but because of the lateness of the hour last evening, we deferred it to today. So at this time, I'd ask the state to approach, and you may make your opening statement.
Thank you, Your Honor. May it please the court. It was awards day at Robb Elementary. The fourth graders lined up throughout the morning and gathered at the cafeteria